Good evening, everyone. Good evening to my colleagues, good evening friends, good evening members of the bar, good evening court staff. Welcome to the Supreme Court Civil Branch to our beautiful rotunda. My name is Adam Silvera, and I'm the administrative judge of this wonderful building. And tonight, we are honored to invite you to the special event celebrating the legacy of the Lemmon Slave Case and the journey of our traveling exhibit. My goal is to move this program along so that speakers, you do not go on too long. But tonight's event is brought to you tonight as a joint venture of the Historical Society of the New York Courts and the Equal Justice Committee of the Supreme Court Civil Branch of New York County. The goal of this venture was simple yet profound. It is to share the story of the Lemmon case and its historical context with communities statewide. In doing so, we hope to inspire reflection, spark conversations, and foster a deeper understanding of the Lemmon case's legacy. I urge you to enjoy the exhibit, and it will be here for at least another month or so. It's been traveling, and you will get all the further details from Chief Judge Littman and Ms. Marcus from the Historical Society. So I want to take this opportunity to acknowledge and recognize the numerous dignitaries that are here with us this evening, and I apologize in advance if I miss someone. But it is an honor and a privilege to have with us the Honorable Carmen Saparic, former member, former associate, former Associate Justice of the Court of Appeals. We have with us two surrogates. The surrogate of New York, one of the surrogates of New York County, Hillary Gingold, is here. And I understand we have a wonderful, great turnout of Nassau County. We have the surrogate of Nassau County, Margaret Riley. Thank you for being here. I'd like to welcome and acknowledge numerous, we love Nassau County, Vito DiStefano, the Honorable Vito DiStefano, Administrative Judge of Nassau County. We have with us Andrea Phoenix, District Court Judge. She's co-chair of the Equal Justice Committee of Nassau County. Thank you for being here. And we have the Supervising Judge of the County Court of Nassau County, Teresa Corrigan. Thank you. We have a lovely turnout of appellate division judges. I see Ellen Gesmer, Barbara Kapnick, Kelly O'Neill-Levy, and we have a retired, I think she's often known as the Dean of the First Department. I see Carla Moskowitz. I can't forget you. If I can say one thing, when I was a child, it's Judge Moskowitz who allowed my family to keep my dog. So thank you, Judge Moskowitz. I could never forget you. But when the co-op wanted to kick us out, Judge Moskowitz saved us. We also have with us, I see the Dean, she'll always be fondly known as the Dean of the First Department, Angela Mazzarelli. And we have numerous Supreme Court judges, civil court judges throughout the city that are here. Thank you. Thank you, my colleagues in Supreme Civil that are here. We also have Justin Barry, the Executive Director of OCA. And I will never forget my colleague in the Bronx, the Honorable Doris Gonzalez, the Administrative Judge. And my colleague across the street, the Honorable Ellen Bybin, the Administrative Judge of the Criminal Branch, Supreme Court, New York County. Okay, so let me take this opportunity. We also, goes without saying, but I'm going to do special introductions. We are honored to have our Chief Judge, Rowan Wilson, that is present. And we get to welcome back home a familiar, friendly face, the Honorable Jonathan Littman. But I am going to stick to the program, and it is just such an honor and a privilege to introduce our first speaker to provide welcoming remarks. She's a trailblazer. She is none other than our presiding justice, the Honorable Diane Renwick of the First Department, Supreme Court Appellate Division. Her historic appointment by Governor Hochul in June 2023 makes her the first woman of color to serve as the presiding justice of any appellate division in this state, and only the second woman to lead this court since its creation in 1894. I'd like to also note that Justice Renwick's judicial career began when she was appointed as a housing court judge in 1997. She later that year was elected to the civil court. In 2001, she was elected a justice of the Supreme Court. And in 2008, Governor Patterson appointed Justice Renwick to the Appellate Division, First Department, making her the first African-American woman and the fourth woman ever to join the court. It is an honor to welcome Presiding Justice Renwick to the podium.
Good evening, Chief Judge Rowan Wilson and the many other distinguished guests who are in attendance this evening. Good evening to all of you. I'm honored to be here with all of you. Thank you, Administrative Judge Adam Silvera, for covering everyone else so that I do not have to. Thank you for that warm and generous introduction. As one who hails from the Bronx, I am, of course, honored to be presiding justice of this unique and distinguished county that is also encompassed by the First Department. It's always a pleasure to be here and also to be, I love historic buildings, and of course the AD1 is certainly one of them. So it's always a pleasure to be here at 60 Center Street in this amazing building with its beautiful WPA mural. I think this one's The Law Through the Ages, but it's always a pleasure. I don't get to be here enough, and it's lovely to be in this beautiful, beautiful court. This evening, I also wear the hat of a trustee of the Historical Society of the New York Courts, and I am so pleased to join you for this presentation on an important piece of history and New York State jurisprudence. As a New York State judge and an African American, the Lemmon case represents to me more than just an inspiring legal case. From its inception, it was an extraordinarily important case and statement against the institution of slavery. It continues to serve as a potent reminder of a horrific part of our country's history that has led to the stubborn persistence of racism, which unfortunately continues to plague us today. The fallacies upon which racism is built cannot be undone without telling the true stories of the inherent strength of enslaved African American people. Truth is the only way to counter falsehoods. This is but one of many untold true stories. I applaud Judge Rosenblatt for unearthing this important piece of history and underscoring the intelligence, persistence, and resilience of the enslaved people who endured these circumstances and sought their freedom, as well as those who helped them to attain their freedom. It took the courage of those who brought the Lemmon case, the courageous litigants, Emmeline Thompson and Nancy Johnson, who demanded freedom for themselves and their children, the courageous lawyers like William Evarts, who represented the litigants, and the courageous abolitionists, Louis Napoleon, a conductor of the Underground Railroad, who dictated a habeas corpus petition despite not knowing how to read or write, and brought the families to freedom in New York. It also took courageous judges to decide the Lemmon case, including Judge Elijah Payne, the New York trial judge who initially freed the Thompson and Johnson families. Thank you, Judge Rosenblatt, for being a curious and tenacious advocate of New York's jurisprudential history, and for bringing to the forefront these all but forgotten human stories in the struggle for equality that echoes through today. Thank you.
Okay, before I introduce our next speaker, I also want to apologize. I can't believe I forgot to acknowledge the chief clerk of this building, Dennis Rayo. And I'd like to thank our wonderful, capable staff who put this all together. Thank you, Team New York County. Also, my apologies for not recognizing former Court of Appeals Judge, the Honorable Judge Rosenblatt. Okay, we have our next speaker. It's my pleasure to introduce and welcome to the podium our next speaker, the Honorable Deborah Kaplan, who's the Deputy Chief Administrative Judge of the New York City Courts. Prior to this position, since January 2018, Judge Kaplan served as the administrative judge in Supreme Court New York County civil term, one of the busiest courts in the nation, dare I say planet, and I think I know a thing or two about that. And Judge Kaplan capably and fearlessly led this courthouse through the COVID-19 pandemic, ensuring that justice will be served in this very building. Judge Kaplan also served as the interim administrative judge for civil and criminal matters in Richmond County. And prior to that position, Judge Kaplan was a statewide coordinating judge for family violence cases. Please welcome the Honorable Deborah Kaplan.
Good evening. Thank you for inviting me to give some very brief remarks. It really is an honor for me to be here at 60 Center Street and to be a small part of this incredibly important program. And to acknowledge first our remarkable Chief Judge Rowan Wilson. In addition, you've heard from her already, but very privileged to be here with our presiding justice, Diane Renwick from the First Department. Our remarkable former Chief Judge of the New York State, Jonathan Littman, as well as our DCAJ for Justice Initiatives, the Honorable Edwina Richardson-Mendelson, and thank you, Judge Silvera, who I know that's why they give us 8 days a week to work to run New York County Supreme Court. But I really want to say a special thank you to the New York Historical Society, led by the wonderful Marilyn Marcus, whose passion, drive, and commitment resulted in fruition of bringing the program of inestimable value to us. But finally, let me just take a few seconds to shine a light on retired Associate Judge of the Court of Appeals and author extraordinaire, Albert Rosenblatt. And many who played a role in the Lemmon Slave Case, and indeed the case itself, was really all but forgotten. But Judge Rosenblatt has brought the story of this seminal case to us in astounding words in his book. And I have to say that I am a long-standing fan, Judge Rosenblatt, of your written work, having first been introduced to you when I became a judge by receiving the complete annotated book on search warrants, which I always kept on my bench in court. Now, on the eve of the Civil War, the Lemmon Slave Case appeal was argued in the New York Court of Appeals, and our highest court affirmed the lower court's decision that held that transporting slaves into the free state of New York made them free, even if the slave owners meant only to move the slaves from one slave state to another slave state. Now, if you know me, I like to look into things a little deeper, and I like to look at people who aren't really mentioned as much when we know a historical story. So I'm going to focus for just a few seconds on William Evarts, who ably argued the appeal, but he's someone who's barely remembered today. There's really no park or high school or statue named for William Evarts, despite having been an exceedingly gifted lawyer and statesman. And Evarts was quoted as saying, "The world can absorb only doses of truth. Too much would kill the world." And some truths are difficult to absorb. And one such truth is that not until 1865, some 5 years after the New York Court of Appeals rules in Lemmon versus New York that the 13th Amendment to the Constitution formally abolished slavery. And another truth that is deeply painful to contemplate, but we must, every day, remember that racial biases continue to pervade, to invade our society. And until that is not the case, we must dedicate ourselves to obliterating racism and bias of every kind in our court, in our communities, and in our society. And my role as a judge and court leader is incredibly clear. I am charged with doing all that I can do to eradicate all forms of racial bias, discrimination, and harassment in our courts. However, the duty to enforce the court's zero tolerance for racial inequity policy extends far beyond judges and court leaders. It applies to everyone who is part of our court system. Each one of us is tasked with helping to create courts which promote fairness and diversity, courts where every person who works there and every person who comes here seeking relief that only we can provide is treated with the respect and dignity and civility that is their right. It is our obligation to embrace that mission and to fulfill it with focus and fervency and the urgency that it demands. Thank you.
Thank you, Judge Kaplan. I also want to take a moment to acknowledge the presence of our county clerk, Milton Tingling, that is with us. Thank you, Judge Tingling. And now our next speaker is the Honorable Edwina Richardson-Mendelson, the Deputy Chief Administrative Judge for Justice Initiatives. In 2017, Deputy Chief Administrative Judge Richardson-Mendelson was appointed to head the newly expanded New York State Unified Court System's Office for Justice Initiatives, tasked with ensuring meaningful access to justice for all New Yorkers in civil, criminal, and family courts, regardless of income, background, or ability. In service of this mission, the Office for Justice Initiatives administers help centers, self-help services, pro bono attorney, and other volunteer programs, and many other resources designed to serve unrepresented court users have access to justice. It is also important to note that Judge Richardson-Mendelson was appointed to the Court of Claims in 2017 and is very active on that bench. I don't know how she does it, but she does it, and does it brilliantly. And prior to that, from 2003 to 2017, Judge Richardson-Mendelson was a family court judge in 2003, supervising judge at that court in Queens County, and was elevated to the administrative judge of all New York City family courts. Please welcome the Honorable Edwina Richardson-Mendelson.
Thank you, everyone, for this privilege to appear before you today, our final stop on this remarkable tour of this remarkable and critically important exhibit. In 2020, our New York State court system joined the rest of the country and the world in our most recent reckoning on racism and its impact on all of our institutions, including our courts. We are engaged in a full-hearted, renewed commitment to equal justice endeavors as we implement the recommendations made by our special advisor on equal justice, Secretary Jay Johnson, in his report that assessed our courts for racism and bias. And what have we done? We've done a few things. In addition to creating an award-winning mandatory anti-bias training program for all of our judges and court staff, as well as an award-winning jury orientation implicit bias video that is being adopted in other jurisdictions like California. We importantly have established equal justice committees throughout the state court system, and they are court-based equal justice committees. Indeed, this court's own Equal Justice Committee is co-sponsoring this event today. Each committee operates independently and powerfully, but we gave these committees 2 mandates, and they are not asks, they are mandates. The first is that each committee must engage with community, because we cannot eradicate racism and all forms of bias, and we cannot promote equal justice for all unless we engage courts and community. So that's the first thing. But the second is to learn local history. And that is why I'm so excited about what we are doing here with this remarkable exhibit. Local history. A few blocks from here, the New York Stock Exchange, the stretch of land from Pearl Street to Water Street is where our enslaved ancestors were rented and sold at market. Enslaved labor built many things in New York State, including the wall after which Wall Street is named. We can travel a bit further to Ulster County, New York, in our 3rd Judicial District, where famous abolitionist and suffragist Sojourner Truth boldly walked up those New York step courthouse stairs, entering a building that I am privileged to enter and that you should visit, demanding and receiving justice on behalf of herself and her stolen son who was sold into slavery out of state. We travel a bit further to Saratoga County in that region of our state and have the legacy of Solomon Northup, 12 years a slave. All New York history. Important examples, and only a few examples, of the rich, painful history that we must recognize, acknowledge, learn from. Equal justice is indeed local. So I offer my deep thanks to the Historical Society for all you have done in bringing this remarkable exhibit throughout our state. There is so much about which we must be proud. And I'm going to end by reading our renewed court system mission statement. I'm proud of that too. That came out of the pain point of 2020 and our reckoning on racism in society. Our new mission statement. The first statement was our base and existed. What comes after the first piece of it is new. The mission of the unified court system is to deliver equal justice under the law and to achieve the just, fair, and timely resolution of all matters that come before our courts. I expect that's in every mission statement in every court in the country. Here's where it gets exciting and thrilling for me. In the service of our mission, the unified court system is committed to operating with integrity and transparency, and to ensuring that all who enter or serve in our courts are treated with respect, with dignity, and with professionalism. We affirm our responsibility to promote a court system free from any and all forms of bias and discrimination, and to promote a judiciary and workforce that reflect the rich diversity of New York State. Aspirational, inspirational, we have much work to do in our courts, and events like this, including what just happened now, play a big part in us meeting our mission. Thank you.
Thank you, Judge Richardson-Mendelson. And let me just say, you are one class act. Any litigant is lucky to have you hearing their case. Okay, now our featured speaker We are honored to have with us the Honorable Rowan Wilson, Chief Judge, our esteemed Chief Judge of the Court of Appeals and the Chief Judge of New York State. And let me give you a little bit about his background. From 1984 to 1986, he cut his teeth in a courthouse all the way out west, serving as a judicial law clerk to the Honorable James Browning, Chief Judge of the United States Court of Appeals for the Ninth Circuit, based in San Francisco, California. Chief Judge Wilson may have grown up and born in California, but we claim him as New York. In 1986, the Chief Judge joined the firm of Cravath, Swain & Moore in New York City as an associate and was elected to partnership there in 1991. And in that position that he continued until February 2017, when he joined the public sector as an associate member of the Court of Appeals. And we are grateful that on April 10th, 2023, Governor Hochul nominated Judge Wilson to serve as Chief Judge, and the New York State Senate confirmed his nomination on April 18th, 2023. In just a short period of time, he has been doing a fantastic job. It is an honor to welcome, as our featured speaker this evening, the Honorable Rowan Wilson.
Thank you, everyone. I wanted to take a moment, although I think that Judge Richardson-Mendelson did it admirably, to address the interruption. Because the key word that Judge Richardson-Mendelson, used was aspirational. We know we have a lot to do, but we believe that we've assembled a really great team that is all of one mind and one purpose. And the aspiration, and this will seem maybe to some of you laughable, but it is our true aspiration, is that every litigant of whatever sort who walks out of one of our courtrooms at the conclusion of a matter, whether they won or they lost, will think that they were treated fairly. That's the aspiration. I certainly understand why, if I lost my children, I would be irate. And I might do something like that or more extreme. I certainly understand the reaction. We're never going to eliminate that entirely, but it is our aspiration to do so. So this is a wonderful place. We're full of history. I can't think of a better place to talk about history. And usually when I'm in a room, I think, well, there's nobody in the room who really loves history more than I do. But when I'm with Judge Rosenblatt, I have to confess that I'm probably not even a close second. When, I get asked a lot about why this court is called the Supreme Court and my court is called the Court of Appeals. We just had all the judges, Supreme Court justices from around 50 states and some territories and other places we were hosting. And I got asked that question by several of them, and I gave them my stock answer, which goes back into history and explains the names. And as I walked in here today, I realized, wait a minute, I have an additional answer now. And I remembered when I first was nominated to the court and confirmed, I asked, could I have my chambers in this building? And the answer was, no, this is the Supreme Court. And now that I'm Chief Judge of the state of New York, the answer is still no. So there you have it. The events chronicled by Judge Rosenblatt in his book, The Eight, took place at what I think of as the most tumultuous time in this country's history. You could perhaps make an argument for the Revolutionary War, but I think de Tocqueville would agree with me that what the Founding Fathers did was to kick the can of slavery down the road, knowing it was full of dynamite and had the potential to destroy this country at its very foundations. To give you a little glimpse at the turmoil, in the time between Judge Payne's initial decision, freeing the Eight, and the time that before the case came up on appeal, the United States Supreme Court decided Dred Scott, which held that they and everyone like them and many of us here were chattel property and had no rights, could not sue in court, were no different than a ham sandwich or a piece of luggage. A month after the arguments in the Court of Appeals in the Lemmon case, but before the Court of Appeals decided it, Abraham Lincoln delivered his famous address at the Cooper Union that catapulted him from an unknown into a serious candidate for the presidency. In the few months after the Court of Appeals decided the Lemmon case, the Southern states formed the Confederacy and seceded and cited the Lemmon case as one of the reasons that they were seceding. The Civil War thus began. I wanted to share a few of my own observations about the book and about the exhibit. First, we should all be immensely grateful to Judge Rosenblatt for the painstaking research. I mean, you should see the footnotes in this book and read them. It's really a true work of scholarship. But more than that, it's highly literate and incredibly readable. He's given us an account in sort of, I think, the most effective way and most important way to teach history, which is not done very often. It tells a story about real people. It's humanized. It's not a recitation of dates and facts and events that are sort of glommed together. And from that recitation, you can imagine yourself, whoever you are, as various people in this story. You can understand their motivations. You can understand the push and pull, even of the anti-abolitionists. You can understand the forces that were going on. And in that way, it illuminates history in a way that ordinary textbooks and many scholarly articles don't. Second, the Unified Court Systems exhibit, which has started here and has traveled the state, it started and ended here. And it's traversed the state. It stopped at 45 different courthouses around the state in every judicial district in the state. And although the exhibit did not literally travel the path of the Underground Railroad, it did so figuratively. The parallel is both unmistakable and important. The vestiges of slavery persist in myriad places and ways, not just in our physical manifestations, but in the conscious and subconscious beliefs of many, and in public and private organizations. As our exhibit, publicizing Judge Rosenblatt's history of the struggle of the Eight to secure their freedom, traveled throughout our state, it emphasized and dramatized the continued need to stamp out the persistent detritus of slavery and the sorry history associated with it. And it thereby helped to educate and remind New Yorkers that the work of abolitionism is not yet complete. The exhibit, like the New York journey of the Eight, began here in Manhattan, and as Judge Rosenblatt's book recounts, New York City was equivocal in its opposition to slavery. Judge Rosenblatt explains how New York merchants, fearing the loss of Southern business, opposed abolition in general, and the Lemmon case in particular. I offer two additional illustrations that bookend the period covered by Judge Rosenblatt. The Tappan riots of 1834 destroyed black and abolitionist churches and businesses throughout New York City. And the draft riots of 1863, when President Lincoln ordered a conscription order to fight for the Union side, in New York City, white rioters destroyed homes and churches of abolitionists and African Americans and burned to the ground the Colored Orphanage Asylum, which housed 233 children. Finding New Yorkers in favor of slavery was not hard. Finding those who wanted full legal representation and political participation for African Americans was much harder. Third, and on a brighter note, Judge Rosenblatt's careful legal analysis of the trial and appellate decisions in the Lemmon case has profound relevance today. New York State judges then were faced with a Supreme Court and a federal government that supported slavery, including through the Fugitive Slave Act, the Dred Scott decision, and numerous other legal obstacles to emancipation and abolition. Guided both by their moral compass and their understanding that the law is a living organism that must adapt itself to current times and advances in both our knowledge and our humanity, they worked creatively within the constraints imposed by federal law to assert New York's sovereign right to protect its residents, visitors, and territory. The need for that commitment to the protection of New York's interests, for that moral compass, and for that boundless creativity remains vital today. As New York attempts to protect its interests and its residents where federal laws have failed or proved inimical to our welfare. It is not, however, merely brave and sophisticated judges that are needed, but dogged and brilliant lawyers, like those who represented the 8, and perhaps most of all, courageous plaintiffs, like Emmeline, willing to risk their own lives and interests for the chance at a better tomorrow for all. Despite Judge Rosenblatt's exhaustive research, we do not know what happened to the 8. But we do know what happened because of them, and we're all the better for it. Thank you all very much. And please enjoy the wonderful discussion and the video presentation to follow.
Thank you, Chief Judge, for those inspiring remarks. We now have another Chief Judge in the House, and it is a pleasure to welcome you back. The Honorable Jonathan Littman. He's now a founding trustee and currently serves as the president of this society. He, as you know, is the former Chief Judge of New York and Chief Judge of the New York Court of Appeals, and he is currently of counsel in the New York office of Latham and Watkins. Judge Littman served at all levels of the New York State court system in a career spanning more than 4 decades, including service as a staff attorney, administrator, and judge. He was the longest tenured chief administrative judge in the state's history. Very important fact. And he also served as the presiding justice of the appellate division of the Supreme Court First Department. Judge Littman received his undergraduate degree from New York University and his law degree from New York University School of Law. Welcome back, Judge Littman.
Thank you. Thank you, my wonderful, wonderful successor, Chief Judge Wilson, for being here tonight and for your inspiring remarks and for this great crowd in this great rotunda. And I have to tell you, I spent the first 18 years of my professional career with many of you in this building, in this rotunda. And when I see it, there's one name that I just feel I have to mention, and that is Norman Goodwin, who so many of you remember, the notorious Norman Goodwin who signed your jury notices for all those years. He's responsible for the fantastic shape that this rotunda is in tonight. And Norman would be smiling ear to ear, and particularly he would be smiling. I mentioned his name. I was the chief clerk. He was the county clerk or the clerk of the court, and we would fight over who was really the clerk. I knew he was really the clerk, but I would pull his leg all the time. And as long as I mentioned him 2 or 3 times every time I spoke, it was okay with Norman. So it's great to be here with all of you. And on behalf of the Historical Society, as the president of the Historical Society, as a former chief judge, I want to formally welcome you to 60 Center Street, to this rotunda, and to this great event. You know, the Historical Society was formed in 2002 by none other than Albert M. Rosenblatt with Judith Kay, the chief judge at the time. And the mission of the society is to promote the legal history of New York and to promote democracy, justice, and the rule of law. And by so doing, to highlight the New York courts and its critical role in our tripartite system of government, and to increase collaboration between the judiciary and the profession. Since its founding, we have had a real partnership with the courts. And this exhibit really is such a terrific example of that partnership. It's just been extraordinary. And what's also become clear over the years is a greater focus being necessary on the whole issue of diversity and inclusion. And this has been so much also a part of our mission with the bench, with the bar, with the courts, with our staff. And all of us at the Historical Society and all of us who have been in positions of responsibility and leadership in the courts have worked on this effort over the years, and there have been so many milestones starting, and not all of you can remember all these things, but the great Ambassador Franklin Williams, and I remember him so vividly when he came on the scene. Judge Wackler had brought him in, and it was such an interesting time. The Workforce Diversity Program, we try to match the percentage of minority representation in our court workforce with the general population of qualified people in the overall workforce in New York State, and one of the first programs of that kind in the country. I'd also mention the Inspector General for Bias Matters for one particular reason, that Carol Robles Roman passed away just the last few days, and she wrote the script for that office. Again, a key part of our efforts to combat bias in the courts, the ongoing work of the Williams Commission with all the different chairs over the years, the recent Equal Justice Report that Edwina mentioned, the Diversity and Equal Justice Committees in each courthouse, and the work of so many of you in this effort. So we've come a long way, and we certainly have a long way to go. But this program tonight is so much in sync with those efforts and that work. And I can't tell you the pride that we take in the Historical Society in its travels around the state. And the program that you're going to see tonight, you are really in for a treat. We have, who's been mentioned a number of times, Albert M. Rosenblatt, who not only was a founder of the Historical Society and wrote the 8, but is a president emeritus of the Historical Society, and also is the first Albert M. Rosenblatt legal scholar of the Historical Society. How fitting it is that the first Albert M. Rosenblatt legal scholar is Albert M. Rosenblatt. And he is busier than ever. Let me tell you, this man doesn't stop. You know, the book, the promoting the programming of the Historical Society, the teaching, the legal history, the focus on it. But he is going to meet his match today with one of his proteges, and I think I used that word advisedly. David Goodwin is a former student of ours at NYU Law School, is going to interrogate him tonight. And when I say he's a wonderful interrogator, he does this on podcasts all the time. And Judge Rosenblatt, I'm really fearful of the treatment that David's going to give him tonight. But David is terrific. He was one of the founding members of our Young Lawyers Committee in the Historical Society. He's a supervising staff attorney at the Second Circuit. David is terrific, and we look forward to this event. And before we get to it, we've all built up to this event, I just want to ask Marilyn to come up for a few minutes and give you some context of how we get to today, how this thing started and where it sort of developed and wound up in this road show around New York State. So anyway, great to see all of you in this fabulous rotunda. Great to be with you tonight. Thank you.
No, I just have to start by saying how lucky I've been to be the executive director under Judith Kay, Albert Rosenblatt, and Jonathan Littman. Who could ask for anything more? It's been my privilege, really has. So on behalf of our board and staff, the Historical Society is so pleased and proud to bring this event sponsored by the court's Diversity, Equity, and Inclusion Committee. My special thanks to Chief Judge Wilson for his strong support of the project and event and his own deep interest in our legal history. Thank you, Judge. A few years back, Judge Rosenblatt and I were approached by Dennis Glazer, a Historical Society trustee, to consider creating an exhibit that would travel to courthouses around the state. We loved the idea and soon settled on the Lemmon Slave Case, which we had already highlighted in an article on the case by another of our trustees, John Gordon, which appeared in our publication Judicial Notice. Judge Rosenblatt and Dennis, along with students at the St. John's Law School, where Dennis taught, researched the case, its historical setting and cast of characters, and the content and images for the 8 panels were prepared. The artistry for the panels, which is really very high quality, came from students at SUNY Purchase, where Dennis had served on the board. So these were all really contributed services to this exhibit. Then came the final ingredient that makes this exhibit extra special. Through the amazing reach of Judge Rosenblatt, a request was made to James Earl Jones to narrate the exhibit. Lo and behold, he said yes. And the judge, Dennis, and I took a trip to Upper Westchester to meet the great man and record the narration in his home studio. What a thrill. This iconic voice belonged to the Historical Society for this. Once all the pieces were together and the exhibit set to go, we turned to Justin Barry. Justin, OCA Executive Director. Justin was the mastermind behind developing the travel plans for the exhibit, which, as the Chief Judge has pointed out, traveled to 48 courthouses, and what a wonderful metaphor to compare it to the travels of the Underground Railroad, with one extra stop at the Judicial Institute for their own program. It traveled for close to 2 years and has been well received wherever it stopped. Justin did it all and provided us with a calendar of stops and approvals in place. Justin did this with enthusiasm and skill, and his love of history shone through in the conversations we had together. Thank you, Justin. The Historical Society staff then contacted each courthouse as the calendar unfolded to let them know what to expect and to encourage local events around the exhibit. They range from visits to by students and seniors, events coordinated with local bar associations and other dignitaries, and within the courts themselves. And press coverage from local newspapers was pretty widespread for this. Photos of the exhibition and local events were sent to us, and if you take a look at the exhibit that was put together here, you can kind of get a sampling of the kind of events that the courthouses put on. The response was truly amazing and very gratifying. The exhibit was met with enthusiasm wherever it went. My special thanks, and I think this would not have happened without these people, my special thanks to all the district executives, clerks, and staff in all the courthouses for the work they did to showcase the exhibit, and to the court officers for handling the transport. This was truly a collaboration effort between the Historical Society and the courts. It would have made, and I have to take a moment because I'm thinking about it as I see Judge Rosenblatt and Judge Littman here, this would have made Judge Kaye very, very happy, I think. So, we'll start the program with the exhibit video narrated by James Earl Jones, which will have images to accompany it. And then we'll begin a conversation with Judge Rosenblatt, moderated by David. And I did want to make one point, which really brings the book to the exhibit, and that is that the book grew out of Judge Rosenblatt's growing fascination with the Lemmon Slave Case following his research to put this exhibit together. And it was combined with his curiosity about that period of time in New York history and his admiration for the brave young enslaved 8 who were its central focus. So once again, history informs the present. Hopefully we become better because we know our history, and I hope you enjoy the evening. Thank you.
By the 1850s, a decade before the Civil War, slavery caused harsh disagreements among the northern and the southern states, and even within families. In New York, where slavery had been outlawed since July 4th, 1827, and where many New Yorkers were active abolitionists, there were also divided loyalties on the slavery question, as the banking and shipping industries maintained strong commercial ties to the cotton and sugar trading interests that originated in the South and in the Caribbean. The Lemmon case presented a direct conflict between slaveholders and New York abolitionists. In 1852, Juliet and Jonathan Lemmon, residents of the slave state of Virginia, decided to move to Texas, another slave state. For the first leg of their journey, the Lemmons traveled on a ship named the City of Richmond from Norfolk, Virginia to New York City, where they disembarked and waited in a hotel for another ship to take them to Texas. In addition to all their worldly possessions and their 7 children, the Lemmons brought with them 8 slaves. Emmeline, who at 23 was the head of her family, which consisted of her 16-year-old brother, Louis, her 13-year-old brother, Edward, and her 2-year-old daughter, Amanda, and Nancy, who was 22 and the head of her family, which consisted of her twin 7-year-old sons, Louis and Edward, and her 5-year-old daughter, Anne. Nancy's husband, the father of Anne, was himself a slave. The Lemmons group, 17 people and all their possessions, arrived in New York on Friday, November 5th, 1852. Louis Napoleon, a free black man and a New Yorker very active in the abolitionist movement, had learned from a steward who worked on the city of Richmond that these 8 slaves had been secretly brought into New York and were being held in a small, overcrowded hotel room. The following day, Louis Napoleon, unable to read or write, but keenly educated as to how to use the New York courts to help free slaves, dictated a writ of habeas corpus to the clerk of the Superior Court, marked an X on the writ as his signature, and commenced a court action which sought to free the Lemmon slaves. Through his extensive connections with the New York abolitionist movement, Louis Napoleon made sure that the Lemmon slaves were represented by a first-rate legal team, which included John Jay, a grandson of the founder by the same name, and Chester A. Arthur, who went on to become the 21st President of the United States. The case was heard before Judge Elijah Payne. On the strength of Louis Napoleon's initial papers, Judge Payne ordered the slaves brought to the courthouse, and after a short delay to allow the Lemmons to hire a lawyer, Judge Payne heard arguments from counsel and ruled that all 8 slaves should be free. The Lemmons argued that under the laws of Virginia and the United States Constitution, they held proper title to the slaves as their property, and no court could take away their property rights, although courts had ruled that way before. Judge Payne's ruling, controversial at the time, were based on 2 principles. First, Judge Payne found that because the Lemmons had voluntarily brought the slaves into New York, a state that had outlawed slavery 25 years earlier, The slaves were emancipated under New York law and were now free. Of greater historical importance, however, Judge Payne ruled the slaves free based on a higher moral authority. Beyond New York law, Judge Payne wrote,
"By the law of nature, no one can have a property in slaves."
While the Lemmons appealed from Judge Payne's decision, the abolitionists involved in the case secured prompt passage for the now freed slaves to move north from safe house to safe house, the so-called Underground Railroad, which was well established in New York State. They ultimately resettled in Canada, where they could be safe from any appeal taken by the Lemmons. Judge Payne's ruling in the Lemmon case was extremely controversial at the time. Northern abolitionists pointed to it as a just decision, while some slaveholders in the South cited the ruling as an important reason why the Southern states should secede from the Union, complaining that Northern courts were not adequately protecting their property rights. Appeals were taken all the way to the highest court in New York. Nonetheless, in every appeal, Judge Payne's decision to free the slaves was upheld. The Lemmons ultimately tried to take their appeal to the Supreme Court of the United States, but by then the Civil War broke out, and the Lemmons could not appeal further because Virginia had seceded from the Union. Interestingly, since under the laws of Virginia, the 8 slaves were considered property held by the Lemmons, and since the court ruling had the effect of taking slaves away from the Lemmons, New Yorkers involved in the case and other abolitionists voluntarily raised a fund of $5,000, valued at over $100,000 today, to compensate the Lemmons for the economic loss they suffered by bringing their slaves to New York. In return, the Lemmons agreed that no matter how any higher court ruled on appeal, they would no longer contest the right of their former slaves to live free. Judge Payne himself contributed $100 to the fund. By paying this money to the Lemmons, the abolitionists ensured that the former Lemmon slaves would never again have to be concerned that a ruling by a court would return them to slavery.
We have to hit the buttons. Hello, everyone. What an amazing video. Welcome, Judge Rosenblatt. Before we begin, I just want to quickly incorporate all prior recognition and thanks that's been extended to everyone hosting this event tonight under the law of the case doctrine. It's just all incorporated into this discussion. And I'm sorry, Judge Littman, this is going to be more of a conversation than an interrogation, but we'll do our best. So, Judge Rosenblatt, welcome. And I want to start in, I think, the obvious place. I mean, this exhibit, the Lemmon Slave Case, such an important moment in New York history. If you don't mind, if you could tell us a little bit about how you became interested in the case and how you brought this exhibit to be.
Well, I may look this old, but I actually was not around at the time the case was decided by the New York Court of Appeals. It was decided by the court in 1860. I arrived in the court closer to around 1998 or 2000, so I was there a century and a half later. But the judges in the building and the folks in the building in the Court of Appeals in Albany know the court's history. They know that we decided the Lochner case. They know that we decided McPherson against Buick. They know some of the cases, not necessarily in detail, but they knew the Lemmon case, as I did, as a case in which the court somehow oversaw and affirmed the release, the discharge of 8 slaves, in contrast to the Dred Scott case. And that's about all we knew. And one day I decided to actually read it, and I read the case. It's not easy reading. I don't recommend it. If you want to find it, for the lawyers in the room, it's 20 NY. It is not easy reading because the goal in those days was not clarity, it was more ornate. But after I understood the case, I became enamored with not the abstract principle, but with the people. And this is a case about real people, and that then generated a lot of research into what turned out for me to be a narrative and, you might say, an adventure story.
And focusing, I think, on those people, one of the really amazing things, so, you look at this exhibit, they're referred to as the Eight, but it wasn't until the video we just watched that we heard their names said. And, while this isn't a book event, it's also not a book event. One of the amazing things your book does is really humanize the Eight and situate them in the context of everything that's going on both in the state and the country. So can you talk a little bit about who you learned these people to be and kind of what their roles were in taking this remarkable step for themselves as the case went on?
Yeah, for most of us, the COVID was a setback, and we were not allowed to go out and do our usual work. We were quite restrained and inhibited in many ways. But for good fortune, I was able to use that particular time seated at the desk 12 hours a day, locked in there and doing research. So I am no expert on the operation of the computer, but learned my way around the internet and was able to uncover facts by digging and making a lot of phone calls and speaking to librarians and speaking to historians, and came to learn the identities of the Eight people whose identities, as you might imagine, at the time were not recorded with any degree of meticulousness. It was like eight enslaved, ages 3 to 23, and you just had to dig to get their names and their birthdays. But eventually, these abstractions took on life and, in turn, heroic proportions. The most heroic, in my mind, who was Emmeline, who was there were two moms in the Eight. So the Eight consisted of the two moms, young boys, and the rest tots. And the two moms made the choice that they would try to get their freedom and put their lives in the hands of a judge about whom they knew virtually nothing.
And a judge about whom they knew virtually nothing. And also, one of the things the book makes so clear is that we've talked a lot about context and what's going on in the world. And, now looking back, we know the historical context in which they acted. But they didn't necessarily know the historical context in which they acted. And in fact, the social structure in place was designed to keep them from learning about what was going on in the world. And there's one particular moment you describe in the book that I just thought was so striking in terms of taking a step into the unknown and seizing agency. I believe it's during one of the first court appearances where they're in Judge Payne's courtroom, and Juliet Lemmon confronts the two moms you were just mentioning. Can you talk a little bit about what happened then?
Yeah, to your point, not only were the enslaved kept from learning anything, but it was a crime for any white person or any black person to teach an enslaved how to read or write. So they understood and appreciated, of course, that they were in a court of law and that the judge was about to make a ruling on a very vexing legal issue. We could talk about that a little later down the road, because there were vexing legal issues in the case that was a case of first impression. But the scene that you described was one in which the two moms are sitting in the courtroom. Judge Payne is listening to the argument, and at a break, Juliet Lemmon, the owner of the Eight, goes over to the two moms, and just think of the irony of this, and she says to them, the owner says to the enslaved, "Why are you doing this to us?" I mean, that's almost, it's inconceivable to just wrap your head around the owner saying, "Why are you, the enslaved, doing this to us? You are depriving us as owners of our estate and of our entire wealth." And the two moms hear this, and I don't have to make this up, and I didn't have to add any literary license because there are news accounts, and what I did in the book was basically quote the consensus of news accounts, which were pretty uniform in the way they described it. The two moms started to cry, and in one of the news accounts, they just said, no, we're going to stay here, we're going to seek our freedom. And in another news account, one of the moms said, we are not one big happy family as you say we are. You sold my husband. And when I researched that, I did learn that Emmeline's husband was in fact sold off. And this was one of the perils of being enslaved, that it was the nature and fundamental principle of the institution to break up families so that the loyalties would run not to the family but to the owners.
And speaking of perils, they took this step, the 8, knowing full well what would happen if they did not prevail.
Yeah, what a good point that is. I didn't have to create any literary license, but I did say maybe Emmeline and Nancy saw something in the judge's eyes as he was listening to the case, but they could not possibly have known how he was going to rule. And if he would rule against them, they probably knew that it would be no fun to return to owners whom they tried to escape from. So that was quite a risk that they were taking.
And they did this also despite a federal regime at the time, and you write about this so eloquently in the book, that was so weighted against them in terms of federal commissioners and the way that New York was doing what it could to try to counterbalance that extraordinarily oppressive federal regime.
Yeah, this is a fascinating study in what we lawyers call federalism, that we have two universes in the world. Judge Wilson touched on this a little bit. And we have two universes. This does not exist in most countries, but we have two universes going out there side by side. And the federal government and the Congress passed laws that were heavily weighted in favor of slave power. This bargain was hatched in 1787 in the United States Constitution, which recognized that slavery existed. It created the 3/5 clause, which in a sense proclaimed that slaves were 3/5 of a person. It's a little more complicated than that, but that's the takeaway from it. And it also contained a provision that is in the Constitution today. So if you were to take out your vest pocket copies of the Constitution, you would see that the Fugitive Slave Clause still exists. And by that slave clause, recipient fora jurisdictions must return an escaped slave to the owner. And that was in the picture, and that was something that Judge Payne was confronted with when the owners were arguing that he had no right to take away property from owners, even though they had title under Virginia law.
And it's not just the statutes themselves. There was also this Prigg decision by the Supreme Court that was looming out in the background before Dred Scott was even in the picture.
Yeah, Prigg against Pennsylvania, you should read that. That's worth reading. That decision has not gotten the notoriety that it really deserves. In Prigg, Pennsylvania declared that anyone who takes a black person off the streets and kidnaps that person and gives that person into slavery is committing a Pennsylvania kidnapping. Makes sense, right?
Absolutely.
But the United States Supreme Court said that Pennsylvania may not legislate at all and may not create a private criminal kidnapping statute because it would go against federal preemption. It was one of the first federal preemption cases, indeed the most notorious. I think Prigg goes down as something that we should remember. And on the strength of Prigg, the United States Congress then passes the Fugitive Slave Act of 1850, which is also something that as lawyers you might want to look at, because it is a monstrous piece of legislation in which the United States Congress declared that there's a group of federal commissioners, not real judges, but commissioners, who hold power over the lives of alleged escapees, and that these commissioners, when they rule that a person was identified as a runaway, they get twice as much money as if they ruled for the runaway, who denied maybe being the person who they were seeking. Also, under that provision, the escaped slave, or the alleged escaped slave, was not allowed to testify. Just imagine that in today's world of due process. And thirdly, that Americans, citizens, were obligated to help the Federals catch the slave. We were all under a duty to help the federal slave catchers. That was the Fugitive Slave Act of 1850, and it was only 2 years later that Judge Payne dealt with the Lemmon case.
And against this background, you have Judge Elijah Payne, elected in 1849, I believe, to the New York Superior Court. Tell us a little bit about him. Who was he, and how did he have the fortitude to stand up against a regime like this?
A little bit obscure. Those of you who are good with the internet might take a foray into the internet, and you will not find Judge Elijah Payne. I mean, not everyone in the world or every judge in the world is in the internet. I could not find him. He did not exist in the internet. I found his father, who's also named Elijah Payne. So if you go punching in Elijah Payne, you'll find Elijah Payne Sr., who was a United States Senator and a federal judge. They came from Vermont. That might tell you something, because Vermont was the only state in the Union that outlawed slavery in its constitution. So the Payne family came from Vermont, and they were a privileged family. They sent young Elijah off to Harvard at age 15, and to my extraordinary, I was joyous when I read it. I contacted Widener Library at his school at Harvard University and said, "What can you tell me about Elijah Payne?" And I asked them whether they could give me his course of study, and they did. And in the course of study were some of the legal philosophers that he cited in his Payne decision. Isn't that just amazing? It was such fun to get that instrument back, and I got to learn a little bit about Judge Payne. But again, you cannot see what he looks like, and we do not know what he looks like from the internet. But the Payne family is a well-known American family, maybe just a notch below the Adams family. So I called the Payne family historian and said, "Do you know anything about Elijah Payne?" And I gave his dates of birth and death. And she says, yes, we know about Elijah Payne. I said, "Do you know what he looks like?" And she said, "I have his portrait on my mantle." Wow. And then we saw it earlier. He was a handsome young dude and a very good guy. I became enamored with Elijah Payne because there were heroes in the Lemmon case, both black and white. The Emmeline and Nancy, Elijah Payne, Erastus Culver, the lawyer for the Lemmons. Boy, he was an aggressive lawyer who brooked no nonsense, and he went in there with John Jay II fighting for the enslaved, and it was really an inspiration.
So, by the way, if there are any law students in the audience or who are watching, let it be known that your course of study may come up to be relevant for you in the future, so pick carefully. You mentioned some of the lawyers, Judge Rosenblatt, but there was also a name that keeps coming up and who is in fact staring at me right over there on one of the primary placards in the exhibit. Who was Louis Napoleon?
Louis Napoleon was one of a cadre of people who knew their way around the New York docks. And such people existed far beyond New York, but they were so-called engineers or conductors in what we call the Underground Railroad. The Underground Railroad was not something with tracks and a choo-choo train. The Underground Railroad was a series of safe houses occupied largely by Quaker families who recognized the immorality of slavery. And when an escapee, a fugitive or runaway slave, got out from South Carolina or Georgia or Virginia and found their way up through Maryland and Pennsylvania, they would be taken in by a Quaker family, and then sent up to the next home, maybe a mile or two later, and then they would say, well, go up to the next home, and the next home, and the next home, up through central New York State, up through the Great Lakes, and into Canada, where they would find freedom. This was the Underground Railroad. There were thousands and thousands and thousands. We don't know how many, but a great many thousands of those. And the records of the Underground Railroad, as kept by Louis Napoleon, who was a free black man of extraordinary intelligence. He was illiterate, so that when he brought on the writ of habeas corpus with Erastus Culver, he signed an X, but he was a super sharp guy, and they were able to bring the writ before Judge Payne. And on his death certificate, it's in the book where it says occupation, it says conductor, Underground Railroad. That's what the physician wrote in, and he probably had a chat with his physician while he was in his last days, and the physician wrote in conductor, Underground Railroad. What a guy was Louis Napoleon. Unfortunately, we don't know what he looked like. We know he was black. We know he was extraordinarily resourceful, and his papers and the papers of Sidney Howard Gay that sent so many people to Canada are in the Butler Library in the rare book room at Columbia University.
Well, we can hope that someone is hiding his portrait on their mantle somewhere, so one of these days it might yet be discovered. So we heard from James Earl Jones about the substance of Judge Payne's decision, but after that gets handed down, then the appeals begin. So could you tell us a little bit about that process? Who are the lawyers, for instance, who are handling the appeals?
Yeah, I can talk. This is an audience of lawyers, so I can speak a little more technically and a little more freely, because in other talks, it would, I think, mislead or confuse people if I were to talk about standing, or if I were to talk about how in the world the New York Court of Appeals distinguished Dred Scott and things like that. But as you know, as lawyers, there were litigants in the case, and the litigants were the 8 seeking freedom and the owners resisting it. Well, that case was decided by Judge Payne, and when he released the slaves, the case was over. The Lemmons got paid by a large amount of money that was raised by New York merchants. So they were out of the case, and they swore out a bond saying they're paid, and it was in the nature of what we today would call a settlement. So they're out. The 8 are in Canada, so they're out, and they're no longer they're not in the jurisdiction of any court anymore. So what's left of the case? As lawyers, you know the answer to that: nothing. Mm-hmm. In comes Virginia, and they say, well, we want to appeal to what was then called general term, but it was the appellate division. So they said they wanted to appeal the appellate division, and then John Jay II and Erastus Culver said, who are you? Where do you even have standing to come in here? You're another state. You have no interest in this case. And Virginia said, yes, we do. We have a real interest in this case because our people, heaven forbid, are not allowed to bring slaves through New York anymore, and we really care. And the judges at the appellate division said, okay, we'll hear you out. And the appellate court at the first level heard the Lemmon Slave Case in 1857. They affirmed 4-1 in a very, very good, crisp decisions, as the best aptives write when they are at their best, which is usually always.
And as this process is ongoing, Dred Scott is handed down. Right. And so how does Dred Scott end up having a role, or not having a role, as the case may be, in the eventual appeal to the New York Court of Appeals?
Yeah, this was puzzling me as I was doing the research, because Dred Scott is the elephant in the room. Right. And you could read a million cases about slavery, equality, civil rights, and so forth. But there's Dred Scott, which was decided after Judge Payne's ruling, but before it reached the appellate division. And one would think that the premium lawyer in New York, named Charles O'Connor, would walk in to the appellate division and say, Dred Scott, and sit down. He did not do that. And that baffled me. And I have some theories if anybody wants to have a cup of coffee sometime about it. But he did not pound the table with Dred Scott. He did cite it, but he cited it almost fleetingly. And the appellate division didn't even cite it because it was not pressed upon them. What he did was at the appellate division and before the New York Court of Appeals, even though he was the premier lawyer in New York, Charles O'Connor, my goodness, all the great civil cases, all the great financial cases, he made the mistake that novice lawyers make. He did not know his audience. So he goes before the appellate division and ultimately before the Court of Appeals, and he says, this case must be reversed because, as everyone knows, blacks belong in slavery. We took them out of Africa. We Christianized them. We humanized them, and they belong in a subordinate position. And the judges, you could just see them sitting there listening like, and what is your second point? And I'm just guessing that's probably the way it was because they never, the appellate division and the Court of Appeals never even addressed that argument because it was really beneath any kind of discussion. But when the case reached the New York Court of Appeals, the court affirmed the aptive 5-3 and thereby affirmed Judge Payne. I don't want to talk about the three yet. I can talk about the three dissenters, and they wrote a very cogent dissent, which we could talk about, but the majority ruling was based on two judges. Hiram Denio wrote one majority opinion. William Wright wrote the other majority opinion. Denio's decision was textbook, scholarly, right on target. William Wright's decision said, now let me talk about Dred Scott. No one is talking about Dred Scott too much, so I'm going to talk about Dred Scott. And now I'm reading this thing and say, oh my, like, wow, okay, tell us about Dred Scott. And he said, as some of you may know who practice in the federal courts were always that had jurisdiction by virtue of diversity. And you know before you go into a federal court, you need strict diversity, a citizen of one state suing a citizen of another state. And the Dred Scott decision recited initially the jurisdictional basis for the lawsuit. And they said, Stanford is from New York, that's okay, that's one citizen. Dred Scott cannot bring suit and has no capacity to bring suit because he is not a citizen of Missouri. He is not a citizen of anything. He is an ex-slave, therefore he is not competent and cannot be a citizen of anything. That's the beginning. The rest of the 50 or so pages, our court said, is dicta, and we chose not to follow it. There you are. And as lawyers, you must appreciate how deft that was on the part of William Wright. And I looked and I said, wow, well, I wouldn't know enough to call him by his first name. I said, well, way to go.
And I mean, when you recite Charles O'Connor's arguments and also the way you deal with Dred Scott, I mean, one of the other things the book really does is emphasize just the sheer mask-off nature of so many of these arguments. And so distinguishing Dred Scott as dicta is, one way to deal with the banality of evil, but it ended up being a very effective way. So the Court of Appeals renders its decision. It's got the two opinions you talked about. And then we also heard a little bit about this from James Earl Jones. There's the conflict. It's teed up. It's going to go to the Supreme Court, and then nothing.
Yeah, this is another bafflement that an author sometimes encounters. We all know that the United States Supreme Court, this is the court that gave us Prigg and Dred Scott, that if they ever got their hands on the Lemmon case, it would have been a reversal. Who knows, 8-1, maybe who knows what, but it would unquestionably have been reversed. Why didn't it ever get there? A mystery that I can never solve, but I'll tell you what my research encountered. The New York Court of Appeals decided and affirmed in April of 1860. There was 9 months before South Carolina was the first state to secede. So there were 9 months in which
Virginia could have appealed to the United States Supreme Court. Virginia was still in the Union. No shots had yet been fired on Fort Sumter. The war was almost a year off. What happened? Why didn't Virginia file a notice of appeal? So I read, a whole bunch of history books, and one or two authors said they thought Virginia did file an appeal, and I thought, well, if so, where was it? What happened? So after a few phone calls, I get to the historian of the United States Supreme Court. He's in the Library of Congress. His name is Ennis. He's a very nice guy. I finally get him on the phone and say, you are the court of last resort. You can answer this question. Was there ever a notice of appeal filed in the United States Supreme Court in the Lemmon case? And he said, after looking it up, he said, flatly no. I said, well, now, Mr. Ennis, I'm going to put your answer in a footnote. So I want you to understand that this is going into the book where Ennis at the Library of Congress said no appeal. I don't want to say this on my own. I want to quote you as the authority. And he says, go ahead. There was no notice of appeal filed. I thought, why? Well, you can guess as well as I can. Guess number one. The governor of Virginia at the time was named Letcher, and he was at odds with a previous governor who said that the Lemmon case was an act of war. Letcher did not like this earlier, and maybe there was some bad blood between them. Maybe he didn't want to follow through. Theory number two, which may actually be the case. The people in the governor's office are talking to one another, and they said, I thought you were going to file the notice. Oh, my goodness. Oh, you thought I was going to file. I mean, that's how the real world happens. And if I had to guess, I would guess that that's just what happened. Or that Virginia was so wrapped up in secession and in the Civil War, they just said, what's the difference? Nothing's going to matter anyway. I'm not a betting man, but I'm just thinking that they should have filed anyway, but they didn't. And my guess is they, for reasons that I just said. Who knows?
Sometimes a blown filing deadline can mean justice. So what is then the reaction countrywide? So this case made the news at every single stage, but what is the takeaway of how the rest of the United States, grappling with all of these issues, is watching the Lemmon Slave Case?
Well, when South Carolina seceded, they were the first to secede. They seceded in December of 1860. They seceded about 9 months after the ruling. And you can go online and look up secession statement South Carolina, and you'll see it. And among the reasons they give, they say, and furthermore, look what New York has done to us. The judges in New York, they won't even let us bring our slaves through New York. That's how bad it is. That's why we have to get out of the Union. So they kind of made us famous in their secession. But Lemmon had influence elsewhere. Ohio passed a statute codifying Lemmon, saying that anybody that goes to Ohio with their owners is free, and Maine did much the same. There's another little point that you might appreciate as lawyers, and we chatted about this. During the oral argument, when we have a record of that, we have the record in which the lawyers for the owners were arguing before Judge Payne, and they were saying, and under the Fugitive Slave Act of 1850, the recipient states are obligated to give the slaves back to their owners. And Elijah Payne asks, were they escaping? You know how astute that was? They were not escaping. Therefore, the Fugitive Slave Act does not apply. Oh, my. I don't hear enough of a gasp in the audience, but I hope you can appreciate how astute that was on the part of Elijah Payne, saying, yeah, I know about the Constitution, and I know I have to give back fugitive slaves, but they are not fugitives. They are in the company of their owners. And that's how he got around it, and I thought that was not only deft, but brilliant and correct.
extraordinarily deft and very much knowing the audience of history, I think, which is also a very important thing. So we've been talking for the past few minutes about the case as lawyers, and I'd like to transition back to the person element for a second. You know, it was mentioned, I think, earlier that not much is known about what happened to the 8, but you certainly tried to find out and managed to turn over a few stones. Can you talk a little bit about that process?
Yeah, I never really expected that I would learn the identity of the 8, because when they left New York with the help of Louis Napoleon and the Black Reverend Pennington, they got them on the Underground Railroad. That's the last we hear of the 8 in the public record. There's a letter that went from John Jay II to Buxton, Canada. We know they got to Buxton, Canada, but that's the last we hear of them in the public record. So I called the historian who became a friend of mine, Brian Prince, who was the ultimate record keeper in Buxton of records of thousands and thousands of runaways and others, blacks who got to Buxton, Canada, which was the terminus. I said, do you know the Lemmon case? He said, yeah, of course I know the Lemmon case. I said, is there any way we can find the progeny, what became of the 8? And he says, no, it's just too difficult with names like Johnson, Thompson, Wright, we just can't. So 2 years go by. I'm now ready to submit the manuscript to the publisher. So I call my friend Brian. By this time we're on first name basis. Brian, Al here. Can you take one more look and maybe give me a clue of an iota, of a sliver, of a hint that I can maybe find something of the identity of the 8? And he says, I have reason to think that the 7-year-old boy, Lewis Wright, grew up and went to Lansing, Michigan.
A clue.
So now I only have about maybe 300 people named Wright in Michigan, and I'm looking through census records, voting records, marriage records. You could get all this stuff online, and if you're locked up, cabined up with COVID for 2 years, that's what you do. So I went through all these records, and one morning I'm with Julie in a living room which looked like a police scene with markers and tape and everything else and stacks of paper. I said, Julie, I think I have them. Everything matched. And once I had Lewis Wright getting married in Ypsilanti, Michigan after the Civil War, I was able, through the Lansing newspapers and marriage records and voting records and census records and death records and so forth, to go down 7 generations and find the 7th generation blood descendant of the 7-year-old, who of course has long passed away. And I find his telephone number. You can find anything online, as you know, and make the telephone call. The guy's name was Randy West. Hello, Mr. West. This is Al Rosenblatt. Please don't hang up. I have something important I want to talk to you about. It's not a phony insurance policy, and I'm not giving you some scam, but I think you have, if I have the right person, your family has an important role in American history of racial equality. Who's this? Why are you calling me? So after another couple of these, he understood that it was a legitimate call, and we became friends. And he did know that he was descended from Lewis Wright. He knew that. And I then traced his lineage. I said, okay, your great-grandmother was, I don't remember, I think Flossie Moore. He says, that's right. So I gave him his lineage all the way down, and he knew this was bona fide. But he did not know anything about the Lemmon case. He knew that they came from Lewis Wright, and eventually I met one of the descendants, Luann Merrill, and she gave me a picture of Lewis Wright as a grown-up. And just this past weekend, I was in Buxton, Canada, where I met a lot of the folks who are descendants of the escapees, the runaways who went there over the years. So I met a couple of hundred people, and they had a program up there celebrating the Buxton free status in Buxton, Canada. And it was a great weekend. You know, there was a lot of food and games and baseball games and talks and family history. And they did a reenactment of the Lemmon case. And I got to see Luann Merrill. She was there, and she was the representative of the 8. She's a very talented woman who's a pilot, and I'm going to be seeing her in the future. And maybe even she's watching. Luann, if you're watching, hi.
I mean, we can, we open with thanks. We could also use this as an example of the telephone is not obsolete. So between that and the COVID pandemic, apparently you can find out anything. So it's really extraordinarily impressive. You've been, along with John Gordon and some of the others we've mentioned, just a pioneer in researching and living with this case and learning so much about it and contributing so much to, I think, the richness of New York State legal history for so long. If you could encapsulate your experience researching this case in sort of one anecdote, one moment, what would that be?
Well, it'd be hard to put in one moment. It's hard for me to find a single moment, although there were many, the drama in the book, but just the notion that I could uncover and maybe tell a story that is so important. The story had been forgotten for decades and decades, and we're able here in a group like this to revive it and to bring the mind to the importance of racial equality, a challenge that we live with all the time, that is so important to us as we Americans live in a society where we value equality and racial equality, and hopefully to just go forward and keep fighting the good fight.
I can't think... I can't think of a better note to end on, truth be told. So thank you so much, Judge Rosenblatt, for sharing all of this amazing work you've done on the book. It is The 8. Thank you, everyone, again, for having us. And, thank you so much.
Thank you.
Thank you, everyone. This wonderful event is concluded.